First, the head of EQC says they've sought legal advice on the extent of Fletcher Construction's liability for any substandard repair work after the Christchurch earthquakes. Sid Miller told us that a short time ago. He also told us EQC is now assessing Fletcher's liability as a project management office. That's a major development after a week of interviews on Checkpoint in which we revealed the contract between EQC and Fletcher's contained an indemnity against liability for the construction company, and in which the National Party's new EQC spokesperson suggested EQC should sue Fletcher's if there is an overwhelming amount of substandard work. Tonight we reveal how many cases against EQC are before the courts, and it's quite a lot, and we do it all in an interview with EQC CEO Sid Miller. Speaking to us for the first time since he took over the job from Ian Simpson last February, we begin with Mr Miller listening to the experiences of 4 of the many EQC clients we've spoken to on Checkpoint over the past fortnight.
EQC turned up when they had finished. I raised concerns about there being liquefaction under the house, and he told me that he had looked under the floor and that there was no liquefaction under there. That surprised me because the access to the underfloor area was in a cupboard under the stairs, and I was in a position to see that nobody had even been into that cupboard, let alone looked under the floor. So I asked him how he had determined that there was no liquefaction under the floor, and he told me that he had looked down the manhole and had shone his torch around thoroughly, and that's how he determined. And I just said to him, "You're a liar." And he sort of looked shocked at me, and I said to him, "You're a liar, because if you'd looked under the floor, you would have noted that there is black polythene that we put on the ground under the house prior to the earthquakes, and you can't actually see whether there's liquefaction under there unless you climb under the house, lift the black polythene and have a look." And I said, "And I know that you didn't go under the house."
During the inspections and all the time I was with EQC, nobody ever looked at the underfloor. When they were inspecting the damage, they did not inspect under the floor. When they were inspecting for land damage, they did not look under the floor until I complained and got a review. When the reviewer came out, he got under the house, came up and saying, "Oh, there's hardly anything there, barely half a bucket." I consequently received a letter saying that he saw only 0.01 cubic metres of silt under the house, and it was costed at $2.05 to remove. My insurance company, as a result of negotiations with my lawyer, put a critter under the house which not only showed a lot of damage, broken bearers, parted bearers, cracks round the foundation, tilted piles, etc., but masses of silt inundation under the house.
It took 3 years and going through 8 different people to finally get an engineer to say that the damage to the foundations was earthquake related. Mostly they just did very casual inspections, sketches on bits of paper of what the rooms were like, very basic notes about cracks in the walls. No attention was made to the floors at all at the time. It was incredibly frustrating because I actually used the term in one of my emails, like, "Are you calling me a liar about how my house was like before the quakes?" And it was really disheartening that the government-run organisation could be doing this to me or to anybody. We didn't really push our repair for several years because we thought we trusted the process and the government to look after us. But it wasn't until this started to happen that we realised that they were not on our side. Bits of the house has now started to rot. We haven't been able to do maintenance that you would usually do on a property over that sort of period of time to keep it up to spec. And that's a bit sad, do you know what I mean? We won't be able to use 2 whole rooms of our house properly because of the state that it's now in.
You can look under our house from a trapdoor. They did stick their head in under the house, shine a torch round, and from that site you could actually see that there were at least 2 piles collapsed, and that there were at least 4 piles that had completely lost their footing because of land damage, because of the slope having moved. And they just ignored that. So they were putting to jack and pack piles that had actually fallen over. So that was the joint review between EQC and Southern Response. and they ignored the cracks in the foundation. They said it could just be epoxied, and they ignored all the framing damage to the house. We went from being a rebuild to being under cap, and then had to fight to get away from EQC. And since then, we've been stuck with Southern Response in this maze of delay and denial.
And they are just some of the people we have been speaking to and have heard from over the past few weeks. Sid Miller, CEO of EQC, thank you so much for joining us on Checkpoint, and thank you for listening to those people. What do you say to them?
It's very distressing, John. Very distressing to hear that and what they've been through. We need to address these problems, and I think what I want to do is make sure we hear from all of these people. I want to make sure that we can, address the outstanding claims that we've got, and where people maybe have issues themselves that they've not actually submitted that they're aware of, is please come to us. We have to solve these issues.
Yes, and I think everyone listening will immediately be comforted by your determination to listen to them. But I want to ask you, how many cases is EQC currently defending in the District Court, the High Court or the Appeal Court, or preparing to defend from claimants like the people we just heard from?
We have 316 open litigation cases at the minute, of which I think 58 are in the District Court and 257 are in the High Court, and one is in Court of Appeal.
Can you give me the overall number? 300 and how many?
316.
So you want to listen at the same time as you have 316 claims in court?
We have to resolve the open claims that we have got, and those claims that I've just talked to you there about in litigation. What we've got to do is try and find a settlement for those people there as well. So I'm very much focused on dealing with that 2,600 that I know you're well aware of, but also dealing with those in litigation as well. So how can we find a route through those? And so that's our overall focus. Is everybody who's in these positions in terms of trying to get their claims resolved is where we are focusing. But I take your point. It's not a space we want to be. So I absolutely agree with you. It is time that we look for different resolutions for these people.
What we're talking about here is work that was either done and disputed or wasn't done. And a lot of that goes back to the original scopes, doesn't it? And you will know that on Checkpoint over the past week or two, we've been looking at the fragility, the flaws, the omissions of many of the original scopes. How big a problem do you think that was?
It's hard to know how big a problem it was, when I look at this. But I know there was initial sort of rapid assessment done, which was very much about checking whether houses were safe and people could live in those. We then went into a process of further scoping completed by certified builders, and then working with the contractors and then even the customers themselves to understand was all the scope being covered, and how did we could get sort of a constantly iterative process to get variations to that statement of work to deal with damage as we got deeper and deeper into the repairs. So I think there was a process in place there that was followed. But there's clearly... Forgive me for interrupting, because I'm determined I'm not going to interrupt during this interview, because we really are delighted to hear from you. There was a process that was followed. What does that mean? Because you see, what we're hearing is that those initial scopes, and everyone knows the pressure that was on you in that period post-2011, February 2011, there was 180,000 scopes done in 4 months. It was unbelievable. But what we are hearing from Fletchers, who of course ran the Canterbury Home Repair Program, and from senior managers within the Canterbury Home Repair Program, is that the scopes became binding in a way, that it was very difficult for people who had been scoped to get the extent of their damage reconsidered. Now, what we are talking about now is a whole lot of people who think they were repaired, who had cosmetic repairs done and have no idea what is lurking in the foundations beneath their floors, right? Look, look, and I say to those people, then if you have concerns, please contact us. Your claim remains open with us. We will come back and we need to have a look at what is concerning people. What are they actually finding? I mean, what is it we're not seeing? And so that's where I encourage people to please contact us. And some of the things that I'm looking at are do we need a separate line that call line that people can contact us on? In terms of, we have our info at eqc.gov.nz, and I'm quite happy there. If they want to put on the subject line checkpoint, please contact us. I want to solve these issues for people.
What are we looking at most of all, do you think? Is it the pre-1970 rubble foundations, and there are lots of new homes in Christchurch, so let's say that they are in roughly a half to 2/3 of the property stock that existed prior to the 2011 earthquakes. Those foundations are most vulnerable, aren't they?
I couldn't comment on that, John. I don't have that level of technical detail. What I can tell you, of the 2,600, we have 1,273 that are in the re-repair category.
And 1,273, and the re-repairs are mostly two foundations, would it be fair to say?
I wouldn't know. I couldn't comment on what the ratio. Some will be foundations, but some will be, there could be walls, there could be, I don't know. I can get that for you, but I don't have that to my fingertips, I'm afraid.
Right. But the issue again is we may simply not know how many foundations need repair work until people find that out themselves. That may be years from now. Onsolds are providing a striking example of that. That is people who bought properties in which the EQC scope repairs were actually done. There was paperwork to say that, and they've only found out subsequently, as new owners of the homes, that the foundations weren't scoped and therefore weren't repaired.
I think the unsold situation is a very complex legal situation, both with ourselves, with the private insurers, and I know this is one of the areas that the Minister has specifically asked for resource to be dedicated to, so that she can seek a declaratory judgment, because we need to find a solution through this. We continue to pay to our liability, but absolutely understand your point, and the people that are left with this problem. So we've got to find a solution for this, and that's the reason we're looking for that. We're working to support the Minister around this declaratory judgment.
You say that you continue to pay to your liability. Is there a increasing reluctance from insurers to do the same thing?
The insurers are adopting their own position in this space. So this is, where people are finding themselves is a challenge for the whole.
But what's really interesting is that
industry.
Yeah, but what's really interesting is that if your original scope was under cap, and then you find new damage right in the foundations, then you go over cap. So suddenly the insurers are going to start getting people onsolds who they had no expectation whatsoever of dealing with. And we have IAG and Southern Response both having limitation periods on claims, which mean that all claims must be in this year.
Yep, and that's why we need to urgently seek this declaratory judgment to sort this out. We've got a big legal issue here, which we've got to clarify for people so they can get certainty in terms of where they stand.
Where are you at with that legal issue? Where are you at with that declaratory judgment?
We're working through that.
Jerry Brownlee and his replacement as EQC spokesperson for the National Party say Fletchers are liable for all of this, and EQC should consider taking action against them. Are you?
I've had legal advice, and the advice that I've received is that Fletchers do have a liability. And I'm going to pursue this in terms of looking at the various options. Now, Fletchers were operating a project management office. We had the relationship with the contractors. But their obligations around running the project management office, I want to understand that a lot more and what the legal ramifications of that are. So I am pursuing options in that space, yes.
I want you to clarify that. You are pursuing options that may involve taking legal action against Fletcher's.
They might do in due course, but I don't want to prejudice our position today.
What liability have you been told Fletcher's have?
Fletcher's have liability from the point of view of delivering the services of a PMO.
But there are so many exclusions in the PMO, aren't there? FCC is not responsible for A, the design of the works, B, the construction of any works, C, work of any contractor or consultant, or the goods or services supplied by any merchants.
John, the legal advice I've had is Fletcher's have an obligation in terms of delivering their services as a PMO, and that's what we'll be looking at.
Yes, Fletcher's and EQC, the buck stops where, I guess, is the question. This seems a very good time to bring in another customer of EQC and then of Fletcher's through the Canterbury Home Repair Program. Her name is Catherine Adair. She was pregnant in February 2011 when that big quake struck. Their roof leaked. They were considered highly vulnerable and they were made a high priority case for repairs, as was appropriate, obviously. Thank you for listening to her, Mr. Miller. This 7 years on is where Catherine Adair stands now.
Right now we have a house that is not compliant. It never had any of its council checks done while they were doing the repair. We have been through this huge fight with EQC where they've changed scope time and time again. We've had 3 repairs done to this property. We've moved out twice, and we're still in a situation where we have 400 points of defects: the foundation, the walls, the windows, the roof, the brick cladding, the plastering, the painting, the flooring, and none of them are up to trade standards, and we don't have compliance. We have health and safety risks. We have a fire that blows smoke into the room, and it also has air flowing into the room as well, so it's cold and drafty, and it is unusable.
What did your first scope say? So back in 2011, when you were in that top priority queue because you were pregnant and your roof was leaking, what did your first scope say, EQC scope?
So our first scope said that they would do a full underpin and also do some of the do the work within the cosmetic areas of the house as well, and replace the bricks.
So that must have put you over cap, did it?
Well, no, there was no mention of it ever being over cap until the second repair. Just before the second repair, after at the signing of the scope meeting where we were agreeing what they were going to do, they said to us, you know, you are over cap. However, we would recommend to you that you stay with us because we have it in our best interest, because we've had so many delays, that you should stay with us and we will repair your house. We don't think that you will do any better, and maybe you'll do worse with your insurer. And we don't want you to wait another year before the insurer could repair your house.
And when did they say that to you, Catherine?
This was just before we were about to move out for the second major repair to our home. And
so you are still waiting for EQC to honour that 2 years on?
Well, we did move out. As I say, we moved out for the repair, but we've moved back in after the repair, but as I say, we now have no code of compliance. We've got these 400 points of defects, and there are these health and safety concerns. We've got 3 young children, 6, 3.5 and 10 months. We can't use our fire. There were screws and nails and building site material left around our property, which the children weren't able to go outside. Yeah.
This has been your life for 7 years.
This is what we've been doing. John, I have to emphasise the bullying. They bullied us the whole way through.
When you say they, who, Catherine?
Fletcher's and EQC.
And how did the bullying, how were you bullied?
They threatened to cash settle us if we didn't agree with what they were doing. They said if there was a consent, in terms of the fire, right before Christmas, they said, no, you definitely don't need a consent to put a new chimney in your home. We said, I'm pretty sure you do. Then they agreed that yes, you did, and we asked that they show us the consent before it goes to council because we knew that they could, get it wrong. They didn't give it to us. We got the consent from the council. They'd used the incorrect template. It wasn't our house. They then said to us at that time, if you delay this any further, this work, you will be liable for your rent that we're paying for you at the moment, and you'll be liable for the length of time it takes because of to pay for the scaffolding.
What has been the impact of this on you and your family?
Well, we trusted them. We trusted the process. They said they would fix it. They said they had the right people to do the work, the right professionals, had the right skills. They said, you have to give over everything to us. We will manage this. You're not to be involved in your house repair. And we've lost everything. It's got no compliance. It has no value. It's a damaged home. It's a health and safety risk for our children. We've been bullied to the point where it's traumatised. It's actually a sense of trauma. We feel anxious when EQC contact us or when they come to our home to do assessments. We have flashbacks. It's used our energy, which we would have preferred, and our money. We'd prefer to have spent that with our family. And we have a sense of exhaustion and apathy. And personally, it's made me lose trust in my country. I have no pride in New Zealand.
That's Catherine Adair speaking to us at some length. Mr. Miller, we really appreciate you sticking with us, and we really appreciate you listening to that. And the word that people will have fixed upon, I think, is that they feel bullied by EQC. But the one that I think sums up the tone of so many people we have heard from over the past few weeks, and actually years of doing this work, is that she feels anxious every time she deals with EQC. Is it okay that she feels that way?
John, that was absolutely horrible to hear. And it's just simply not on. People should be able to trust us, and we have to address that. It's dreadful that she is anxious. And look, I'm not going to be able to solve it now, but if she's happy to share her details with you, then if you could please
absolutely
pass those on, and we'll contact her. I think I'd like to thank you for bringing issues like this to the fore. We have to resolve these, and we have to address these issues for people. It's just simply not on.
Yes, and that's what you exist to do, right? And so there are roughly 2,500 re-repairs or people who are ongoing in terms of their pursuit of resolution or settlement with EQC. There are people going through the courts in over 300 cases. When will this be over, do you think?
One of the targets that I put on myself and the team is that of the 2,600, all those that came in before March of last year, which is about 700, I want to have resolved by the end of June. And then in terms of the other repairs, what I want to do is I want to give people certainty that when they do have a claim that's reopened, that they have a timescale by which they know they're going to get a settlement, or at least know how that settlement's going to be resolved, so that I can return some faith in the system. And so they are our key targets we're working to deliver the change. In addition to that is also ensuring that where we do settlements, they meet the satisfaction of the customers from the point of view of not being reopened. So, it's important both what we do but how we do it. So that's what I put in place. That's what I'm holding myself accountable to the board and my team as well. And that's very much our focus for this year.